Sir.
43 minutes remain for the state to reply to the jury or to reply to the defendant's arguments, and I will alert you when there are 3 minutes.
Thank you, Judge, very much. I appreciate that. Thank you. Good afternoon again, or good morning again, ladies and gentlemen. I'm sure you were all told by your mom or dad, grandmother, grandfather, aunt and uncle, that if somebody is willing to tell you an inaccurate statement or misdescribe evidence or make allegations when there are none, that person cannot be trusted. No, anything else he says cannot be trusted. Once a fabricator, always a fabricator. There are allegations made today that in a matter of confusion and uncertainty, the state had first-degree murder and step-downs. In fact, the law requires the step-downs. That's a fact, and that's the truth. Any attempt to mischaracterize it as our choice is false and misleading and indicative. This case, not by any stretch of the imagination, deals with self-defense. When a highly trained man, sworn to protect the lives of others, deliberately, with thought and cunning, shoots his unarmed fleeing brother in the back no less than 5 times, it's betrayal of the highest order. It is murder, ladies and gentlemen, not self-defense. And you know that. Common sense tells you that. You don't even need to look at the law. I want you to look at the law. I want you to study the law and the facts to reach his verdict. But you know from your own way of life how people think that that is murder, not self-defense. I would argue to you it's not even close to self-defense. It's an outrageous act of betrayal. Deputy Martin, a man with hopes and dreams and responsibilities, taken from his family. Why? Because of a punch in the nose? Maybe some insults at a local bar? Is that why he was killed? There are so many decisions that the defendant could have made which would have saved Deputy Martin's life. He could have moved to another room that night. He could have used non-lethal force. He could have resisted the temptation of shooting an unarmed fleeing man. He could have resisted the temptation of shooting 5, 10 times and hitting him 5. He could have checked, stayed in the room, and checked if Deputy Martin's guns were still in the bag. Problem solved. And in fact, if Deputy Martin's guns were missing that night, got on the phone, hey, guess what, folks? We have a madman running the hotel. The duty to protect the public, not himself. This defendant is a trained law enforcement officer. His duty is to the public. The whole time, start to finish, Mr. Chan was in possession of his own gun. Now, ladies and gentlemen, that's a problem if you just use that gun to murder your partner. So immediately, the defendant had to fabricate a story that would put the gun in the hands of Deputy Martin. The defendant never guessed that it would be the science that would prove him wrong. It's clear that Mr. Forster's testimony, clearly and scientifically proven that the defendant shot the first shot into the roof by the positioning and the bullet trajectory. That's a fact unrebutted by the defense. It couldn't have happened any other way. Now, ladies and gentlemen, if you accept that scientific fact that was never rebutted, then all that Dr. Trumpeter had to say is completely and totally irrelevant because it was never self-defense. Make sense? The defendant in this case is not a victim. The defendant is not a victim of alcohol. The defendant is not a victim of circumstance. The defendant is not a victim of fear or stress. He's not a victim of Big Brother trying to persecute him. There's only one victim in this case, and that's the man who can't ever see his children again. The defendant is a heartless killer, a wolf cloaked in the uniform of men and women whose duty is to serve and protect other people. The evidence shows clearly that protecting the life of his partner or protecting anybody in the hotel that night was the last thing on the defendant's mind. The evidence paints a portrait of a selfish man who did everything in his own self-interest, including manufacturing stories. The heck with the public. They're on their own. You know what the public could do? Hide in the bathtub. Isn't that what the defendant told you? We're to believe that this highly trained SWAT officer was frightened and scared of big bad Deputy Martin. Oh my God. So much so that he was forced and had no choice. Here's the key, folks. He's going to try to convince you he had no choice but to kill Deputy Martin dead. You don't take headshots at people unless you want them dead in the ground. And why would the defendant want Deputy Martin dead? You only hear whose story? The defendant's story. Once the defendant shot once, as clearly indicated by Dr. Force's testimony, unrebutted, he had to finish the job. He's a cop. He knows what evidence he has to suppress. Ladies and gentlemen, when a defendant testifies, his credibility and veracity, which means his willingness and ability to tell the truth, comes into question. You don't need an expert testimony to decipher what the defendant said. That's what you're here for. Defendant's posture, facial expressions, and of course, his response to questions sometimes tells more than every other piece of evidence combined. And as you deliberate, I would ask you to critically judge the defendant's testimony. Now, I'd like to talk about some issues that were brought up in defense closing. Your memory, of course, is paramount and the only thing that matters in this case. What you remember of the testimony, what you remember from opening statement to closing statement. I will submit to you that it was never the state's position, now or in the future, that gunshots were less than 2 feet. I would submit to you that was an error in the transcription.
Go ahead.
Thank you. Thank you, Your Honor. I would submit to you, ladies and gentlemen, that I don't believe and never believed that the shots were less than 2 feet, nor did I believe that the defendant was markedly drunk. I believe he was arguably drunk. That's just a quick aside to correct that issue. The defendant starts out waving the flag of the Constitution. That Constitution preserves the right of the pursuit of happiness and the freedom to live one's life without That's when the self-defense claim fades away. This is never a situation where somebody stood their ground. And first of all, let me remind you folks, there is no self-defense claim here because we know through scientific evidence that the defendant fired the first shot. Now, I was taken back by the defense equating the defendant to our first responders and our military. What happens when there's an issue or a problem or a situation requiring first responders? They run into the danger. They protect the people. Our military risks their lives for our country. They don't risk other people's lives. The analogy is so twisted, so wrong on so many different levels. It's clear from the evidence the defendant did nothing to help the citizens inside the hotel at night, only protected themselves. Is that what our military does? Is that what our first responders do? When buildings collapse, do they run in or out? It's a mockery. Now, let's talk about being in cop mode. Mr. Wells, can you help me with this, please? I've put before you, ladies and gentlemen, what I describe as cop mode, murder mode. On the left, under the title of murder mode, is what a murderer would do. And on the right, in the cop mode, is what our cops are trained to do and do every day. As you can see, a murderer shoots at fleeing unarmed men, where cops only shoot as a last resort. A murderer makes unreasonable assumptions about weapons. He may have a gun, I think, I don't know, but it could. To never shooting on a guest. That's what a cop does. Unconcerned about bullet paths, whoever it hits, not my problem. A cop never endangers innocent bystanders. Our murderer is unconcerned about lobby guests. What does that mean? That means if the defendant believed honestly that Deputy Martin had a gun and was hanging down into the lobby, didn't he have a duty to protect the people in the lobby? Or was hiding in the upstairs area by the roof the smartest thing to do? Yes, it was smart. It was smart for him. Tactical plan, hide and protect yourself, where cops are taught to stop the threat and protect others. Now, let's be clear on the facts. When the defendant encountered the first responders on the stairwell, he said nothing about the shooting. Zero. Why? Because he knew he had just committed the crime. That's why. He needed time to think of a response. So he waited till later when he started making these comments that were not specific and couldn't be responded to by the police. Formulating the plan, formulating the plan. The bomb. There's a bomb in the building. Cops try to save lives, not confuse crime scenes and have utter chaos that would have ensued if they would have taken the defendant seriously, that there was a bomb in the building. Defendant and Deputy Martin are in the building, are in the room, 711, at the Aconda Hotel, October 28th, 2014. It's a little after 12 o'clock. Defendant has his gun in his hand. Orders Deputy Martin to sit down. There was a struggle for the gun. We know the scientific evidence, who had the gun and where the bullet went. In that room, defendant shot at Deputy Martin a number of times. When the defendant crosses the threshold of the door, I want you to remember the testimony. Miss Hale, bang, bang, then bang, bang, bang. That is the act. It's a deliberate and calculated act to kill Deputy Martin right then and there. There is no other explanation. There is no other common sense response. Ladies and gentlemen, the last thing I'll leave you with, and thanking you for your kind attention to the details in this case over the past 2 weeks. The plan to kill Deputy Martin was formulated in the room just at 12 midnight on October 26th, 2014. When the attempt failed to end the situation right there, then in the room, there were deliberate, measured shots to take his life. How do we know that the defendant believed himself to be guilty? By his actions after he left the room. I will submit to you this morning that every action he took after killing Deputy Martin was indicative of a guilty conscience, especially given the defendant was a highly trained, SWAT-trained police officer. I don't believe that any fair assessment can be made otherwise. So I'll ask you, after your thorough review of the evidence, and after digesting the jury instructions, to do what the law requires. It's not an easy thing to do, but you have an oath to take that step and, based on the evidence of the law, find the defendant guilty of first-degree murder. Thank you for your attention. Thank you, Judge.
Thank you, Mr. Fields. I am now going to ask the jury to retire to begin your deliberations. You're going to be provided a copy of the jury instructions, and the exhibits that were introduced as evidence will be made available to you. If at any point during the course of the deliberations you would like to want to listen to any of the audios, although there is a transcript, any of the audio that was reviewed during the course of the trial, I am going to ask that we do it in the same manner that we did here in the courtroom. I'll have you come back in. No one will be present in the courtroom other than perhaps one attorney from both parties and the technicians who assisted us in order to play that again, should you need it. But all of the exhibits that have been introduced in evidence will be made available to you. Prior to beginning your deliberations, you're going to need to select one of you to act as the foreperson. That individual will preside over your deliberations and will speak for you here in the courtroom. Again, because of the amount of material that we're dealing with, please be very judicious in selecting who your foreperson is. And let me encourage you all to assist this individual by being courteous, listening to one another, rather than, again, turning it into a very open-ended discussion. Forms of the verdict have been prepared for your use. You're going to find them immediately behind the jury instructions. Please remember, you're going to see 6 documents. Only 4 of them are verdicts. You are going to find a verdict form that is guilty of first-degree murder. A second verdict form that is guilty of second-degree murder. A third verdict form that is guilty of voluntary manslaughter. The fourth verdict that you will find is that the defendant is not guilty. Only 1 out of the 4 verdict forms can be signed by you. Please remember that. The other 2 documents are that right behind guilty of second-degree murder, guilty of voluntary manslaughter, is the question related to whether the crime was committed with the use of a firearm. It requires, again, a unanimous agreement, and the answer is either yes or no. But you only have to answer that question if there is a unanimous agreement that the defendant is guilty of either second-degree murder or voluntary manslaughter. You're going to take these jury forms, you're going to take these forms to the jury room when you've reached a unanimous agreement as to your verdict. The foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any exhibits to the court. Just a little bit of further guidance. It isn't uncommon that the jury could have a question related to the evidence that has been presented. And you've seen that both parties have discussed extensively the evidence that was presented to you along the course with these instructions. The court cannot, the parties cannot respond to a question that is asking, can you explain something? Why did something occur? Why did something not occur? You can't send out questions asking us to embellish or comment on the evidence that has already been presented to you. We would then be enhancing the evidence, which is completely inappropriate. So we cannot respond to those kind of questions, and please understand that. If for any reason that you might have any questions about the jury instructions, we certainly can respond to those kind of questions, but again, let me always encourage you to work together. If there's a difference of opinion related to how to interpret a jury instruction, try to see if you can reach a consensus. If not, then certainly send out a note, and the court will review it with the parties and will attempt to respond to you if we're able to do that. One of the very first things that I told you when we began the trial is that this is a trial to a jury of 12 persons. We began with 15 of you, there are now 14. You understand that in every trial, there are alternates that are selected. These individuals play a critical role. They are there, they are never identified because we need for them to be as focused on the evidence as any other juror. However, their purpose is that if any of the original 12 have an accident, have a family emergency, become ill and cannot continue, we have to have individuals that step into their position without us losing any effort, any effect during the course of the trial. understand that all of you, and I congratulate you, all of you have made a very concerted effort to carry out your responsibilities in this trial. Nevertheless, having said that, the alternates that were selected that are remaining with us are Ms. Laura Gonzalez and Ms. Linda Brown. Ms. Gonzalez and Ms. Brown, you will remain here in the courtroom with us. The rest of you are now excused to begin your deliberations. I know that it is 12:10. We have already ordered lunch for the jury. It should be waiting for you in the jury room, or it should arrive within a few minutes. Again, you will commence your deliberations at this time. You're now excused to begin those deliberations, except for Ms. Gonzalez and Ms. Brown.
All right.
Ms. Brown or Ms. Gonzalez, do you have anything in the jury room? Then Mr. Gonzalez will bring it out to you. Let me, again, there's various ways to respond. Although normally that's not the case in a 2-week or over a 2-week trial. I have to believe that you're disappointed that you can't see this through to its conclusion with all the effort that you put into it. But as the alternates, your responsibilities to these proceedings have now come to an end. We'll retrieve your personal belongings from the jury room. One of the things that I cautioned you about was not to discuss this matter with anyone until we were at this point. That restriction no longer applies. It is not uncommon, that the attorneys may wish to reach out to you to get your impressions about the trial and the presentation of the evidence. You don't have to speak to anyone if you so wish. However, if the attorneys do approach you, then you're no longer prohibited from speaking. I believe that Mr. Cecil has your personal items, if that isn't everything. And then again, if you need any kind of excuses or anything else from the court, you only have to let us know. But with that, Mr. Cecil will accompany you and see you exit from the court. Thank you again for your services. One of the things that I'm going to inform the rest of the jury, and this applies to you, although your term may come to an end here at the end of May, if you wish, because of the amount of service that you provided, the court is prepared to excuse you from any further service in any of your other trials. Although now, with the experience that you've gained, I hope that you'll consider remaining until the end of your term. But if you wish to be excused, please inform Mr. Cecil, and the court will formally excuse you from any other service during this current term. Have a very good day, and thank you again for your service. We're in recess until the jury arrives at a verdict. Thank you.